and good morning, friends. Welcome to the CEC EduSet Live lecture. Dear friends, as you know that we are carrying a series on general course on intellectual property right, and under this series we have conducted numerous lectures, and I would like to tell you all that in our previous two sessions we talked on patentability requirements in India. Today also we are going to talk on patentability requirements in India, and specifically we are going to get in-depth knowledge on utility. What is utility? Dear friends, for this we have again with us in our studios Mr. Ashwani Sewal. Mr. Ashwani Sewal is Assistant Professor in Faculty of Law, University of Delhi. So without wasting any time, I would like to welcome our guest Mr. Ashwani Sewal, and under his able guidance today we are going to understand more and more about utility. So welcome to the EduSet lecture, sir.
Thank you, Gitika. Good morning, viewers. As Gitika rightly mentioned that we have been discussing about the patentability requirements in India, and as she stated that we have covered two kinds of requirements in our previous two lectures. In one lecture I specifically spoke on the requirement of novelty, and in the next lecture in this series I talked about the requirement of non-obviousness. Friends, today I'm going to talk on the third requirement, which I call a substantive requirements for obtaining a patent, that is the requirement of utility. Before jumping directly to the today's discourse and today's agenda, I would like to recapitulate certain things to all my viewers, which I believe are very important at this juncture to understand or to be understood by them. Well, friends, if you remember in my previous discourses relating to patent law in India, I have told you about some of the substantive requirements to be fulfilled by the person seeking the patent. The very first requirement that one must qualify and one must see or assess while obtaining or thinking of obtaining the patent protection in India is the requirement in the form of exclusion mentioned under section 3 and 4, and the requirement to gauge whether the subject matter over which the person is seeking the protection is falling under section 3 and 4 or not. If it falls under section 3 or 4, it cannot be given a patent protection. So you can say that the invention must not have been excluded by Patent Act as non-patentable. If it has been declared as non-patentable by purview of section 3 and 4, it can never be granted a patent. The next requirement in this row is the requirement of novelty, which we have discussed very elaborately and exhaustively in my previous discourses. This requirement has to be fulfilled by the person seeking the patent, which reads that the person seeking the protection over the new product or process must prove the novelty involved in that process or product. The third requirement, viewers, as discussed in my previous lecture, is the requirement of non-obviousness. So the subject matter over which the person seeking the protection, it must involve an inventive step to ensure its non-obviousness. If there is no non-obviousness involved in the work, in the subject matter of the person, he cannot get the patent protection. And the fourth and the final requirement, as far as the substantive requirements for obtaining the patent or substantive qualifications for obtaining the patents are concerned in India, it is the requirement in the form of utility. It must have some industrial application ensuring its utility. So friends, as you can see on the slide in front of you, that these are the four requirements which we are going to finally check and assess while obtaining the patent or seeking to obtain the patent protection. Out of these four requirements, I have discussed with you the three requirements for obtaining the patent. I have dealt exhaustively with the subject matter requirement, I have dealt exhaustively with the novelty requirement, I have dealt exhaustively with the third requirement in the form of non-obviousness, and of course I am going to discuss with you the fourth and the final requirement, which I call a requirement of utility, the industrial applicability of the work or the subject matter. Friends, one more thing which I would like to put across at this juncture, that would again a repetition or a recapitulation of my earlier point, that in India these substantive requirements, and in UK these substantive requirements are called new, inventive step and capable of industrial application. These are the terms that are used in India and UK when it comes to patentability requirements or qualifications for obtaining the patent in India. We have these terminologies used in our Patents Act 1970. So is the case in UK. But friends, in US, the terminologies are different, as highlighted by me in my previous discourses also. In US, they are called novelty, non-obviousness and utility. Apart from one more requirement, which is a requirement of subject matter, under section 3 and 4 it has to be seen of the Patents Act 1970. But in US, these requirements are termed as novelty, non-obviousness and utility. And as I mentioned in my previous discourses, especially discourse relating to the patent law, that these terms can be used interchangeably. In India and UK, the terms are used new, inventive step and capable of industrial application. But in US, the terms used are novelty, non-obviousness and utility. So as I said, and as written in the TRIPS, these can be used interchangeably. So we will be using them interchangeably. Sometimes I may be calling one thing as novelty, or sometime I may be mentioning the similar thing as new, or requiring a newness in it. I believe that is sufficient for you to understand that these two things are similar, can be used synonymously. Well friends, some more important points to be repeated and required to be repeated at this juncture for all of you to understand today's discourse and today's agenda. Well, as you all know that these requirements in the form of novelty, non-obviousness and utility, they are separate requirements, but they are related requirements of patentability. When I say that they are related requirements of patentability, I mean to say that under the Patents Act 1970, these requirements are not defined and described explicitly or expressly in one provision of the Patents Act 1970. Rather, these requirements are given under the definitional clause of section of Patents Act 1970 under section 2, interspersed in many of the provisions or many of the clauses of the section 2. So from there we will have to take them out. Moreover, when we talk or say that these are though separate but related requirements of patentability, this fact can easily be understood by one simple point, that in the case of the novelty, it is only one prior art which has to be checked, but in the case of non-obviousness, multiple prior arts are to be referred and checked. I believe all my viewers remember it, that in the case of the novelty, it is only one single prior art which has to be checked and assessed. If your work has got a similarity with the one prior art, one single prior art, or you can state it in another manner, if one single prior art available into the public domain have got a resemblance with your work over which you are seeking a protection, in that case your work will not be novel. But on the other hand, in the case of the non-obviousness, friends, multiple prior arts are to be referred. It's not only one single prior art on the basis of which you are going to determine whether the work is non-obvious or it is obvious. So for the purpose of determining non-obviousness in the work, or to determine whether the work is obvious to a person skilled in the art, multiple prior arts in the same discipline are to be checked. Say a prior art in the form of A, B, C, D. These all are to be checked and assessed. And if your work has got some sort of resemblance with these prior arts, which are called multiple prior arts or separate prior arts in this case, then in that case your work will not be called a novel work, non-obvious work, because any person who is skilled in that art, by referring to these multiple prior arts, would have created the same work which you had created. So in that case there is no need to grant the patent, because it lacks the non-obviousness, notwithstanding that it is novel. That is one point of the repetition. Well friends, the another important point as mentioned in the slide, that the determination of these requirements proceeds on the assumption that the work in question is not prohibited by section 3 and 4. This I believe everyone understands. If the work is out of the purview of section 3 and 4, only then it is patentable, because section 3 in its marginal note reads that what are not inventions, or it covers what are not inventions. It means works mentioned under section 3 and 4 are not patentable. So whatever falls outside the purview and gamut of section 3 and 4 becomes automatically patentable in India. subject to the condition that it fulfills rest of the requirements for obtaining the patent, requirement in the form of non-obviousness, requirement in the form of utility, a requirement in the form of novelty to be established. Well, friends, let us see today's deliverables for us. As I mentioned in the beginning that we are going to talk about utility, which is the last substantive requirement for obtaining the patent in India. Friends, first of all, we will try to understand the concept of utility. The next thing that I am going to do is, when is utility evaluated? We have to understand all the nuances relating to the time period, because it is essential, I will call that it is highly essential to understand by the person seeking the patent as to when he is supposed to evaluate the utility, or as to when the patent office is supposed to evaluate the utility in the claimed invention. The third thing, why is a need to evaluate the utility? Why the utility is to be evaluated? What is the purpose of evaluating the utility? Or you can say in a simple manner, why a work must give a promise having a capability of industrial application. The fourth thing, we will see or gonna see some case laws on utility which will make the concept of utility clear to all of you. Well friends, let us start with the very first thing, which is understanding concept of utility. Friends, this requirement of utility is very important to be understood by a person engaged into the business of obtaining a patent, or engaged into any kind of a work which he or she thinks can be granted a patent protection or can become eligible for obtaining the patent protection. Friends, the simple point that he or she must take in his mind or keep in his or her mind is that the work over which the person is seeking the protection, that must be capable of industrial application, that must be capable to be used in an industry. If it cannot be used in an industry, if it does not promise the capability of industrial application, then in that case that work will not become patentable, irrespective that it is what? It is novel, it is non-obvious, and it is a subject matter to be given a patent protection. So friends, this requirement, which seems very low kind of a bar for obtaining the patent at a very low threshold, is not that easy a requirement. It is a very complicated requirement to be fulfilled by the person, because as I mentioned in my previous discourses, friends, that it is possible that a person may fetch a patent protection on his or her work, but the validity of the patent can be challenged on the ground of novelty, can be challenged on the ground of non-obviousness, can be challenged on the ground of subject matter requirement, and can also be challenged on the requirement of utility, which is the fourth and the last requirement for the obtainment of the patent protection. If your work does not promise or guarantee the utility, the capability of industrial application, in that case the patent office may refuse the grant of the patent to that person. If the patent office erroneously grants the patent protection to the person, in that case any person interested in getting the patent invalid, declared invalid, can approach the patent office by filing opposition during the patent application if the patent has not been granted. If the patent has been granted erroneously, then post grant opposition proceedings can be availed by the person opposing the patent on the ground of utility. And if it is proved and established before the court of law that the work in question which has been granted a patent does not have a utility here means what? Capability of industrial application, then it can be then it can be refused the patent if it has not been granted, and if it has been granted, then it can be declared invalid grant of the patent. So that is why, friends, it is very essential and necessary to prove the industrial applicability or the capability of the industrial applicability. It's not the industrial applicability finally, but there must be some capability involved in the work to be applied industrially or to be used industrially. Well, the another thing that we are going to discuss when understanding the concept of utility, the case laws on utility. Well friends, let us come to utility. I would like to cover this important saying by Mr. Judge Giles S. Rich in Nelson versus Bowler in 1980, that practical utility is a shorthand way of attributing real world value to claimed subject matter. Friends, if you have a look at this saying or this holding in this judgment by Judge Mr. Rich in 1980, it reads that practical utility is a shortened way of attributing real world value to claimed subject matter. It means that the work over which a person has sought a patent protection must show or must be attributed with a real world value to claimed subject matter or with that subject matter. If it does not or cannot be attributed with the real world value here means or signifies, or you can say it epitomizes primarily the utility of that particular claimed subject matter. If there is no utility lies in that claimed subject matter, then it has got no real world value. In that case, it is not patentable. So I believe it is a very simple saying or a simple holding by Mr. Rich in this case, which emphasizes on the requirement of real world value, which emphasizes on the requirement of utility to be involved in the work. If it is not having an industrial applicability or capability of industrial applicability, it cannot be granted a patent protection. Well, let me take you to another important statement given by one law scholar, William C. Robinson, in the 19th century. He stated that in order that an invention may be patentable, it must not only be bestowed upon the public by its inventor, but when bestowed, it must confer on them a benefit. No recompense can properly be made to one from whom the community receives no consideration. Friends, I would request all of you to pay your attention to the last part of this statement given by Mr. C. Robinson. It says that no recompense can properly be made to one from whom the community receives no consideration. I would like you to see this statement once again as mentioned in the slide, which reads that no recompense can be given to the person from whom the community does not receive anything. And you can state it in another manner or can understand it in another manner, that if the person by his work, by his claimed invention, by his claimed subject matter has not given a promise of any kind of a consideration to the society, of any kind of a benefit to the society, and in this context it is the capability of industrial application of the subject matter. If that is not there, then no recompense should be given to him, and this no recompense in this sentence signifies no patent would be granted to that person, no exclusive right would be granted to that person if he does not promise any kind of a consideration to the society at large. Well friends, kindly have a look at this slide once again, because it is very important to see it for you all, that this statement was given in the 19th century. It reads that in order that an invention may be patentable, it must not only be bestowed upon the public by its inventor, but when bestowed, it must confer on them a benefit, confer a benefit to the public at large. Only bestowing an invention on the person is not sufficient. As per this statement given by C. Robinson in the 19th century, only conferring an invention to the person is not sufficient, is not enough. What is to be given to the public, what is to be bestowed to the public are the benefits of that invention, and the invention will remain beneficial only in a case when it has got a capability to be applied industrially, or it has got a capability to be made or used in an industry. Otherwise, that particular invention will be superfluous, will be useless, and will be redundant at all, not at all necessary, not at all conferring any sort of benefits to the public at large. Well friends, let us move ahead and see few more important points to make the conceptual basis of the concept of utility or of the requirement of utility. Well, the purpose behind the utility requirement is quid pro quo for society. Well friends, this purpose can be called a corollary of the statement given by C. Robinson in the 19th century, where he says that it is not the only requirement of the person seeking a patent to bestow the invention to the public. He has to confer the benefits of that invention also to the public. And moreover, in the same statement it was written, friends, that if person is seeking some kind of a compensation, some kind of a recompense by disclosing his work, he cannot be given that recompense, he cannot be compensated, he cannot be given an exclusive right or a monopoly or a grant of the patent if his work does not promise consideration. So first of all, his work has to give some sort of a consideration, and in reciprocity the public at large gives him the exclusive right. He gives the public the disclosure of his work, the best method of working of his work, enables the person skilled in that art to work upon the research or to work with that particular invention, and in lieu of that, the inventor seeking the patent protection on the claimed subject matter gets the patent right. So it becomes what? It becomes quid pro quo, as highlighted in this slide, that utility requirement's purpose is quid pro quo for society. Society gets something and the patenter receives something from the society in lieu of what? In lieu of his disclosure made to the public, wherein he discloses in his specification the best mode of his invention or best mode of the working of the invention. If it is workable, if it is understandable, if it is discernible by the person skilled in that art, then it is fine. Then this particular quid pro quo gets settled or gets established, and that is how the requirement of utility runs in the society or for the patent law in India. Well, the another requirement, another important thing, that the invention must function for its intended purpose. Friends, it is also to be understood by all my viewers that invention must function for its intended purpose. If the invention does not function for its intended purpose but for some other purpose, in that case it does not have utility, or you can say it lacks the utility. It can be challenged notwithstanding that it has been granted a patent protection. What does it mean, friends? In practical terms, you can say if a person A has applied for the patent protection before the patent office and he has disclosed the best method working of his invention, he has got the patent grant from the patent office by disclosing that thing, the best working method, or you can say the utility involved in his work. But later on, when he actually uses his work or applies his work industrially, he is using it in some other manner. His function earlier disclosed was something else, but now he is using it in some other manner, in some other facet. So in that case, it is no more the intended purpose or intended function which his work is playing. So in that case, you can say it has been erroneously granted to that person. His patent can be challenged on the ground of lacking the utility or lacking the intended purpose which is wanted to serve. The next thing that we need to understand while understanding the concept of utility, that the claimed invention must be operative, or you can say it must be operable. If the claimed invention is not operable, is not having operability, then in that case it cannot be granted a patent protection. Friends, as I mentioned that one of the most important requirements for obtaining the patent in India under the Patents Act 1970 is the requirement in the form of capability of industrial application or in the form of utility. So if your claimed invention or if your subject matter is not operable, is not showing any features of its operability or features of its industrial applicability, in that case it cannot be granted a patent. So these are some of the key points that are to be understood by all my viewers and friends while learning the law relating to patents in India, because if your work lacks the utility, and when would this work lack utility? It would lack utility if it is not operable, if it is not having a capability of industrial application. These are synonymous things. The test to see the utility, or you can say test to see the operability of the work is simple. It is kind of a presumption drawn by the PTO on the disclosure made by the person, wherein he files in full specification that his work works in this and that manner. When the PTO gets satisfied with the disclosure provided or reduced by the patentee or seeker of the patent in this case, the PTO grants the patent, presuming that this work is involving utility, or this work in question seeking a patent protection in this question or in particular situation is a work involving or having a capability of industrial application. If it is proved, or if it is kind of presumed by the PTO, then the PTO may grant the patent protection, can grant the patent protection to the person, subject to the fulfillment of other previous requirements promised by the or required by the Patents Act 1970. Well friends, the next thing to be seen as far as utility or its concept is concerned, that not an obstacle, this requirement of utility, friends, is not an obstacle for mechanical and electrical applications, as the utility gets manifested with the use of drawings and diagrams. What does it mean? This point written in this slide, friends, it means that the requirement of novelty gets manifested and demonstrated through the diagram and the drawings provided by the person seeking the patent, if it is the subject matter of the mechanical field, or if it is the subject matter of electrical field, or you can say if it is a subject matter having a mechanical application, or if it is a subject matter having a electrical application. So in these two cases, it is very easy and simple for a person to, or for the PTO, I mean for the Patent Trademark Office in this case, to presume that the work involves utility, or to finally satisfy themselves that the work in question, which has got a mechanical application and an electrical application, is having or involving utility. Because in these cases, in the cases of works which are works of electrical application, works of chemical application, it is easy to demonstrate the work through a drawing and diagram. But you see, there can be many other works which are patentable apart from chemical application works and mechanical application works, or you can say works having electrical application. But for those works, it may be very difficult to see or infer the utility involved in those works merely by seeing the diagram or merely by watching the drawing provided by the patent seeker in that case. So that is why, as highlighted in this slide in the last point, that it is not an obstacle for mechanical and electrical application, as the utility in these cases gets manifested and demonstrated merely by the use of drawing and diagrams. Friends, but the same is not true with every kind of a case, because in other kinds of cases or in other kinds of works, this utility requirement is not that easy to be proved or is not that easy to be presumed, because it poses a great concern in the cases of chemical and biological invention, because it is difficult to convey the utility of the above said inventions through diagram and drawings. Friends, I believe that all of you understands this simple point, that the subject matters are different, or there can be different kinds of subject matter over which a patent can be granted. It can be a subject matter in the form of a chemical or a biological invention. It can be a subject matter in the form of electrical application or mechanical application. What I am trying to convey is that in the case of the electrical application subject matter or in the case of mechanical application subject matter, it is very easy to demonstrate and manifest the working of the patent or its utility or its capability of industrial application merely through the drawing and diagram provided by the person at the time of filing the patent with his patent application. But in the case of some other kinds of subject matter, say for example in the case of chemical and biological inventions, it is difficult to demonstrate the utility or its capability of industrial application through diagram or drawings, because diagrams and drawings are not sufficient in these cases to demonstrate the utility involved, to demonstrate the working involved or the prospective working involved in that work. So that is why with the work to work, the requirement of utility varies and it has to be checked on different parameters. In the cases of mechanical application and electrical application, utility may be gauged and assessed merely by the drawing and diagram if it is possible to be to do the same. But in some other kinds of works, say for example in the case of a chemical and biological work, the utility has to be gauged or assessed, analyzed on some other parameter, not on the parameter of gauging it through the diagram or drawing, because the diagram and drawing of the chemical and in biological work will never demonstrate its working, its capability of industrial application, or it cannot guarantee the prospective working of that particular work or its applicability in an industry. Well friends, some more points. In another important purpose is to disseminate the invention to posseta. Well friends, I believe this point is very easy to comprehend by all of you, as you have already understood in my previous discourse. What does posseta mean? Well friends, posseta here means person ordinarily skilled in that art. One who is ordinarily skilled in the art, if he can understand the working of the patent by the disclosure made by the patent seeker, in that case it can be presumed and assumed that the work in question is having a promise of utility, or it involves the utility, it is capable of industrial application. Prima facie it can be presumed and assumed if the posseta understands it. The another purpose of Patent Act through the requirement of utility is to disseminate the work and its best mode, its best method. Friends, if you remember the requirement of non-obviousness discussed by me in my previous discourse, I would like to recall one important point which I discussed in my previous discourse discussing the requirement of non-obviousness. I told you that for the non-obviousness or for fulfilling the requirement of non-obviousness, multiple prior arts are to be referred. It's not only single prior art which is to be referred, multiple prior arts are to be referred. Or if by referring to the multiple prior arts, if one person who is skilled in that particular art, ordinarily skilled in that art, if he would have created the same work, had he been given those multiple prior arts, had he been known those multiple prior arts, then in that case the work sought by the person to be granted a patent will no more remain a patentable work, or you can say will never be granted a patent protection, because it lacks non-obviousness or it lacks inventive step in it. So same posseta has to be made aware by the requirement of utility, because when a person who is seeking a patent protection in his disclosure discloses the best method known to him of the working of the invention, and he does it because he is mandated to do so while fulfilling the requirement of utility. If he does not prove the capability of industrial application in his work, he cannot be granted a patent. So by manner of proving, asking him to prove the utility or to fulfill the promise of utility or fulfill the requirement of utility, he has to disclose the best method known to him of the working of the invention, best method known to him of the working of the invention, for the purpose of enabling the posseta, Enabling here means so that the person who is ordinarily skilled in that art get enabled to do the same work, and if he is enabled, then as I mentioned that prima facie it can be assumed or presumed that the work involves the industrial applicability. I am saying prima facie, I am not saying that it is conclusive. It is prima facie on the basis of which the patent office may presume or assume that the work has got the industrial applicability. So as I mentioned, this is one of the purpose of the requirement of utility, to disseminate the work to the facilitator, to the person who is ordinarily skilled in that art. Well, let us see what does utility stand under the Patents Act 1970. Friends, I have already introduced this provision to all of you in my previous discourses. Section 21J, which defines invention, and from section 21J itself we come to know about various requirements of obtaining the patent, or various substantive requirements for obtaining the patent. Friends, if you can see, this section under 21J defines invention. It means a new product or process involving an inventive step and capable of industrial application. As I highlighted and mentioned that this section not only defines invention, it provides or requires a person seeking the patent protection to fulfill various requirements which are called substantive requirements mentioned under this section, in the form of that the product or a process must be new, it must involve an inventive step, and the third and the final requirement mentioned embedded under this clause 21J under the definition of invention, it must have capability of industrial application. Friends, if you have a look at this slide, as highlighted and demarcated by me, capable of industrial application, this is one of the most important requirement for an invention to be granted a patent or to be called an invention for the purposes of patent. The capability of industrial application. If it lacks the capability of industrial application, it cannot be given a patent protection. Another definition which comes into the question and which has to be seen by the person seeking the patent under section 21AC, it reads that the capable of industrial application in relation to an invention means that the invention is capable of being made or used in an industry. Well, friends, section 21J defines invention, posits a requirement of industrial application in the last part of this section, but 21C of the Patents Act 1970 defines what does capable of industrial application means in this context. It says that it means that the invention should be or must be capable of being made or used in an industry. It must be capable of being made or used in an industry. So friends, the term capable of industrial application is industry centric. We must learn this point, as it is a key point that the capable of industrial application has to be seen in the context of industry, or you can say this requirement is industry centric requirement. If the work for which the person is seeking a patent has got some industrial application, has got the mere capability of industrial application, then it fulfills the promise which is industry centric promise in the form of utility, and it can be granted a patent. Let us see one more thing. Under 21AC, we have highlighted in the previous slides two important things. While threadbarely understanding the definition of capable of industrial application, which I call that it postulates two things which are as follows. One, invention is capable of being made in industry, and another, invention is capable of being used in an industry. So two things that we have inferred and which we have taken from the definition of capable of industrial application provided under section 21AC are as follows. One, it is either an invention capable of being made in industry or an invention capable of being used in industry. Either it is being made in an industry or being used in an industry. So what does it mean? There can be a work which is merely used in an industry, used as a process, used as a product in an industry, or there can be a work which is being made in an industry, say a product, a final outcome is made in an industry of a thing. So that final outcome should be made through the industry or can be made, capable of being made through the industry, then it is patentable because it fulfills the requirement of utility and rises to the merit of getting the patent protection. In another manner you can say, or through another manifestation of 21AC, you can say that if it can be used in an industry, say one particular person has come up with a process which he seeks patent protection or which he claims patentable, and he has been granted a patent over his process. If that process can be used easily in an industry, then it has got industrial applicability, because as per section 21C, which defines capable of industrial application, we have got two important things to be noticed by all my friends. One is either it is capable of being made in industry or it is capable of being used in an industry as a process or as a product. In both manner you can say it can be used in an industry or can be made in an industry. A process, by application of the process, a product can be made in an industry, and by application of a process, a product can be obtained in an industry. Well friends, another thing that we have to emphasize under the Patents Act 1970 under section 21C is the term capable. As I have been focusing and again and again in this discourse, that the word capable is used. It's not that the work should be having an industrial applicability. Rather, the word capable has been used with the industrial application. It says it must have capability of industrial application. So the emphasis is on the term capable and the term industry. There are two things which one must notice while reading section 21C. One, that the word capable, another the term industry. When we say the word capable, so what we understand by the use of the word capable with the industrial application is a simple notion which is as follows. Friends, when a person seeks a patent protection and he has to fulfill the requirement of utility as a substantive requirement for obtaining the patent, if he shows the capability of industrial application, it is a prospective industrial application that going to take place after obtainment of the patent. It's not in the present while seeking the patent that the person has to prove that it is workable in an industry, it is capable in an industry. He has to show mere promise of industrial application. If he is able to dispel this prima facie requirement of mere involving a capability to be applied industrially, mere requirement of capability in an industry, if gets dispelled by the person in the beginning while applying for the patent protection or while proving the requirement of utility, he can be granted a patent, because the actual making, actual manufacturing, actual industrial applicability comes later when the patent has been granted to the person. But initially he shows mere capability. It's the mere capability which he shows and tries to prove. If it is found capable by the patent office, it can be granted a patent. It may be granted a patent or may not be, because something which is kind of prima facie seems having some sort of a capability to be applied industrially may not later prove or turn to be industrially applicable thing. So in that case it may be refused, but otherwise if it shows mere capability, it can be granted a patent protection. The another thing which is noticeable under 21AC is the term industry. Well friends, as I said that the term industry has not been defined anywhere under the Patents Act 1970, and even in the Patents Rules 2003, the term industry has not been defined. So what kind of a meaning can be attributed to the word industry? Because we have to check or assess capability of the work in an industry. So if we do not know the meaning of the industry, we are kind of in a situation where it is kind of in a dilemma to know what kind of an industry the Patent Act through the usage of the word industry eyeing or envisaging in it. So for that purpose, as I mentioned, the word industry has not been defined, so we can take the general meaning of the word industry. So therefore it can be said that the term industry has been used in a generic sense. Generic sense here means that the term industry has been used in a generic sense. It means that any kind of a industry, be it a agricultural industry, be it a cottage industry, be it a small handloom industry, a small medium enterprise industry, or any kind of a industry for that matter, because the word industry has not been defined in kind of what we call it verbatimly in the Patents Act. So in that situation, when something has not been defined verbatimly, we can take the broad meaning of that term or the generic meaning of that term. So all industries may fall under the meaning of the word industry. So if your work is capable of application in an industry, in any industry, it is be it a agricultural industry, be it a handloom industry, be it as a cottage industry, any medium small scale industry, then it is patentable or can be declared a patentable, can be granted a patent protection. This requirement, friends, incorporates the enable requirement of the patent law. Well friends, this is one more important requirement which is embedded, or which we can call is kind of immersed in the requirement of utility. It has not been expressly stated in the patent law. The requirement of enablement is not stated expressly or exclusively, but the utility requirement itself incorporates the requirement of enablement to be fulfilled. If your work enables a person, enables the person who is ordinarily skilled in that art, who is ordinarily skilled in that art, who is a fusita in that case, or who can easily make out the same thing which you had created, in that case you can say that this utility requirement covers the requirement of enablement of the patent law. Well, let us take some practical aspects of utility. Well friends, as I mentioned that for obtaining the patent protection, the person files the patent application, and with his patent application he provides the specification for obtaining the patent. So when patent application is filed with the specification, it is presumed that it has got the operability, it has got the capability to be applied industrially. So after the patent application is filed, it is presumed that it has got a operability, it has got industrial applicability. This presumption is very important and is generally based by the PTO, is made by the PTO prima facie on the disclosure made by the person in his or her specification with the patent application. If that disclosure through the drawing or diagram demonstrates the working of that particular invention, the office bearer, I mean the patent officer, the controller may grant the patent protection on the requirement of utility or fulfilling the requirement of utility. In case of doubts as to operability, applicant then has burden of proving it. Well friends, as you all know that first of all it is the application to be filed by the person for obtaining the patent, and with that he has to adduce the specification of his work wherein he provides all inputs or best mode about the working of his invention. From that, the patent officer presumes that it is what? It is operable and it can be applied industrially. But what if there is a doubt lies in the mind of the patent officer or in the mind of the PTO while assessing the substantive requirement of utility? So in that case, viewers, the burden of proving the utility in the work or burden of proving that the work does involve a utility, it is always on the applicant. He has to prove it that his work is operable, his work involves utility, his work is capable of industrial application, which we in Indian context understand that his work is capable to be applied industrially, which means that either the invention is made in an industry or it is used in an industry. In two manners we understand here in Indian context, either it is made in an industry or either the invention is used in an industry. In either manner, if it is proved that it has got an industrial application, it can be granted a patent protection because it fulfills the requirement of utility. When there is a doubt and the burden has not been cogently satisfied by the applicant of proving the involvement of the utility in his work, the PTO may refuse to grant the patent. And in another situation, when the PTO may refuse to grant the subject matter, when there lies inherently unbelievable and implausible promise of working of the invention. If the invention is such, if the subject matter is such, which is inherently implausible to understand, which is inherently unbelievable to be operable, then in that case also the patent office may refuse to grant the patent. Friends, this is a very important point to be understood by all of you, that when there lies a inherent implausible promise, or you can say when the work or the subject matter is itself is inherently unbelievable, on what context or on what terms? If it is inherently unbelievable so far as its capability of industrial application is concerned, if it is implausible so far as its capability of industrial application is concerned, then in that case the Patent Trademark Office may refuse to grant the patent protection to the person seeking the patent because that work lacks the utility. Well, let us take one case law relating to utility, friends. The key case law relating to utility is the case cited as follows. It is Brenner versus Mention 383 US 1966 case. Friends, in this case Supreme Court said a very important or a pertinent noting which reads as follows. Patent is not a hunting license. Patent is not a hunting license. It is not a reward for the search but compensation for its successful completion. A patent system must be related to the world of commerce rather than to the realm of philosophy. Well, friends, as mentioned in this case, which I call a key case law relating to or pertaining to utility, is a very simple understanding which says that the compensation paid to the person for obtaining the patent is compensation not for the search but for the successful completion of that work. And when does the work gets successfully completed? In the case of the patents, when that work starts functioning and when that particular invention starts to be used in an industry or made in an industry. If it cannot be made in an industry, if that invention cannot be used in an industry, in that case we can say it has got not so successful completion. So no recompense or compensation would be provided mere for search. Compensation to be provided always for the successful completion. So a patent system must be related to the world of commerce rather than to the realm of philosophy, as cited and mentioned in the last part of the key finding in this case, which I called a key case, Brenner versus Mansion. So it's not only a philosophy which will fetch the patent protection. It's real working which will fetch the patent protection, because it is always said that patent is not only granted to the idea, it is granted to the working of it. It is granted to the tool, it is granted to that particular thing which will become functional or which will become workable or operable in an industry, or which can be used or made in an industry. So for today's, there are certain takeaways for you. As I am going to finish the patentability requirements with this slide, these are some of the points or key points that you must note down or jot down somewhere to comprehensively understand the system of obtaining the patent so far as the substantive requirements for obtaining the patent are concerned. It can be said that the product or process must show a specific utility. If it does not show the specific utility, it is lack of utility, it lacks the utility, cannot be given a patent protection. Must be capable of either being made in industry or used in an industry. These are the key points or takeaways for all of you today. The product or a process must show a specific utility. If it shows the specific utility, promises the specific utility or a prospective utility, while applying for the patent, it can be granted a patent. Another thing, if it is capable of either being made or used in industry, then it can be granted a patent protection, otherwise it cannot be granted a patent protection. Well, viewers, so with this I have concluded this series on the patentability requirements for obtaining the patent, wherein I have covered novelty, non-obviousness and utility today, and subject matter in my previous discourses. In the next discourse, I will gonna start the procedural requirements for obtaining the patent. As I mentioned in the beginning, that the patent has got two kinds of requirement. One is substantive requirement for obtaining the patent, another is procedural requirement for obtaining the patent. I have completed the substantive requirements for obtaining the patent. I am going to start in the next lecture procedural requirements for obtaining the patent, wherein we will require the Patents Act 1970 at our convenient disposal, or you can say readily available with you, because I will be focusing on many of the provisions of the Patent Act, would be highlighting many key provisions or sections of the Patent Act which puts or stipulates procedural requirements for obtaining the patent protection. Thank you very much, friends. Have a good day.
With this note, thank you, sir. Thank you so very much for giving us a very productive session. And dear friends, if you have any queries, then you can mail us at info.cc@nic.in. We would love to solve your queries. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.
Thank you very much.